Morning, Judge. We're approaching on Mrs. Troy Britton. This is the one that, oh, you weren't here yesterday, Judge. Judge Jackson was here yesterday. We were trying to do something, but I asked to bring my client here so she can know what's going on.
Welcome back to another jaw-dropping courtroom showdown. Today, we're diving into a case that has it all: multiple assault charges, protective order violations, and a defendant who just can't seem to stay out of trouble. We're talking about a 19-year-old with 7 prior charges, wanted in another state, and now caught hiding in the backseat of a car with the very person she's legally required to avoid. The judge is about to lay down the law in a way that will leave you speechless. Will she get bond? Will the protective order hold? And what happens when the victim wants the order lifted? Buckle up, because this courtroom drama is about to get intense. Let's get into it.
So, Judge, the original approach yesterday, while Judge Jackson filled in, was the man jurisdiction requested an extension of 2 days, which she granted because it's 2 days and typically do that. But Ricardo wanted the accused to come to court so that it could be a more formal understanding of what's happening. And during that time for this morning, Ricardo's not telling me she is wanting to have a bond set by the court. State as opposed.
Yeah, this is the one where she's like 17 and she's got already like
she's had 7 charges,
yeah.
2 of them
She's
failure.
19, Judge.
okay, 19, right? Yeah. Sorry, I can't. Just you scare me, man. I can't. They're all very violent cases now. You know, you're wanted at state for another. You know, sorry.
Judge, if I may,
Sure.
in talking to my client, you know, she's made valid points to me. And of course, I'm just...
I know you're advocating for your client, and I'm never going to begrudge anyone for advocating. It's your job, I know. But you're 19 years old. You've got 7 priors already. You're wanted out of another state. There are multiple aggravated assault cases. You've got 2 failure to appears. At some point, we have to say when. And now's that point. You scared me, really. I don't want anything else to happen. So,
So the extension was originally granted by Judge Jackson out to the 24th.
I'm not doing any more. If they don't come here by that point, she gets released. Okay? All right. Thanks.
Thank you, Judge.
Thanks.
So,
Hold on. Let's pause here for a second because this is already getting wild. The judge just dropped a bombshell. If the prosecution doesn't show up by the deadline, the defendant walks free. But here's the catch. This isn't just any defendant. We're talking about a 19-year-old with 7 prior charges, multiple aggravated assaults. And she's even wanted in another state. The judge literally said, "You scare me," which tells you everything you need to know about how serious this criminal history is. Now, the defense attorney is trying to advocate for his client, which is his job, but the judge isn't having it. She's making it crystal clear that this pattern of behavior has to stop, and she's not going to let it slide anymore. The tension in this courtroom is palpable. The question is, will the defendant get bond, or is the judge about to drop the hammer? Let me know in the comments. Do you think someone with this kind of record deserves another chance, or is it time to draw the line?
Ms. Esquivel, you are charged with violation of a bond or protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 8th, 2025, in Harris County, Texas, the officers were conducting surveillance on the defendant who had active warrants out of the 178th. As part of a fugitive task force when they observed the defendant's vehicle parked at a location where the defendant was prohibited from going due to an active protection order. The officers then observed the vehicle drive away, driven by the complainant of the defendant's open case in the 178th. The officers then observed the vehicle to have an expired registration and initiated a traffic stop. The officer then found the defendant hiding in the back seat. Both the complainant and the defendant acknowledged that the defendant was prohibited from the residence.
So she was at the
She was
residence.
at the complainant's residence, yes.
Was she with the complaining witness as well?
Yes. They
Okay,
were
so
together.
how bad are we talking the ag assault? Do you mind telling me about that?
I'll tell you about the ag assault, Your Honor. So in the aggravated assault, the officers were dispatched to a disturbance and they met with the complainant who stated he was involved in a verbal altercation at a bar earlier in the morning. And then once the complainant arrived home, he was locked out of his house and had to force the door open. And that started another disturbance with the defendant. The defendant threw several items at the complainant, and the defendant began to strike the complainant on the back of his neck several times with their hands. And the officer observed the complainant to have red scratch marks on his neck. Further, the defendant retrieved a black compact handgun and pointed it at the complainant and racked the slide, thereby placing the complainant in fear for his life.
Okay. Investigative, I'm going to find that there's probable cause to go forward with the case.
Okay, stop everything. Did you catch what just happened? The prosecution just laid out the details of the aggravated assault charge, and it is absolutely terrifying. We're not talking about a minor scuffle here. This defendant allegedly pulled out a black handgun, pointed at the victim, and racked the slide. That's not just threatening behavior. That's putting someone in genuine fear for their life. And get this, the victim in that case? The same person she was caught with in the car, violating the protective order. Let that sink in. She's legally prohibited from being anywhere near this person, yet officers found her hiding in the back seat of his car at his residence. The level of disregard for the law here is staggering. The judge has already found probable cause to move forward, which means there's enough evidence to believe she committed these crimes. Now, the big question is, what kind of bond conditions is the judge going to impose? With a criminal history like this and a charge involving a weapon, you better believe the judge is about to lay down some serious restrictions. What do you think? Should someone with this kind of violent history even be allowed out on bond? Drop your thoughts below.
I want you to understand something very, very clear. The Texas Constitution does not allow me but in extremely limited circumstances to hold someone at bond. Zero bond. This is that situation. I'm going to put a protective order naming this person as a protected individual. If you so much as do anything to violate any of these conditions, I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every person in my county. Do you understand? You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. No weapons, no contact with the complaining witness, and no going. I'm assuming, is it a he or she? Well, it doesn't matter. You're not to have any contact. Don't go anywhere where this person lives, works, anything. Do you understand?
Now, this is where the judge takes complete control of the courtroom. She just delivered one of the most powerful warnings I've seen in a case like this. Let me break down what just happened. Under the Texas Constitution, judges are extremely limited in their ability to hold someone without bond, meaning in most cases, defendants have a right to be released on bond while awaiting trial. But here's the key. This case qualifies as one of those rare exceptions where the judge could legally hold a defendant with no bond at all. Instead, the judge is granting bond but with ironclad conditions. She's putting a protective order in place, banning the defendant from consuming alcohol, drugs, or any unprescribed medication. She's also ordering random drug tests, prohibiting any weapons, and most importantly, enforcing a strict no-contact order with the victim. And here's the kicker. The judge made it explicitly clear that if the defendant violates even one of these conditions, she will revoke the bond immediately and hold her without bond. No second chances. No leniency. The judge said she would do it in a heartbeat to protect every person in my county. That's not just a warning. That's a promise. Do you think these conditions are fair, or should the judge have denied bond altogether? Let me know what you think.
Yes, Your Honor.
I don't want to talk about the case, but
President, I'm a little
Oh.
confused.
who's your lawyer?
Robert Valles, and he's on my case. He was supposed to be here this morning. I'm a little confused.
Do you know, has Bo said he's going to show? We had no idea that you have a lawyer. Okay, so let's do this. What I can do is I can have you take a seat. We'll wait for him to get here. But regardless, I'm putting these conditions on your bond. I've found that probable cause exists to go forward with your case. The only thing I'm telling you now, don't violate any of these conditions because there are severe consequences.
Yes, Your Honor.
We'll go through it again when your lawyer gets here, but just don't leave until he gets here, okay?
Your Honor.
For now, I'm gonna have you sign a reset with Victoria. We'll have you get signed for your conditions. Just take a seat momentarily. Well, once he gets here, then we'll go through it.
Yes, Your Honor.
Okay. Have you heard PC on this, Bo, yet?
Yes, sir. So, Your Honor, yesterday she was on the docket actually so she was on bond for the case out of the 178th, a assault of a family member. They actually, we went up there yesterday. They had her on the docket. There was some issue with the bond and why she was in custody because she never got noticed. So we addressed that yesterday, but she picked up a violation of protective order because when she was arrested for the bond, for the warrant on that, the victim, the complaining witness, her husband, was in the vehicle with her.
And at the house, allegedly.
Yes, sir. Yes, sir.
Are you telling me that that's wrong?
No, sir. That is correct. And that is correct.
Because the only thing I'm doing is no contact, no drugs, no alcohol, and no weapons. That's all I did.
Yes, sir. If I may add, Your Honor, the prosecutors yesterday did call. They spoke with the victim who wanted the order lifted. Judge Susan Brown was covering the 178th. She said she was going to she was keeping it in place where she could not go to the home, but she was allowing contact.
Okay, I'll mirror her order then.
Yes, sir.
Here's where things get really complicated and honestly a little frustrating. So we just heard that the victim, the same person who was allegedly threatened with a gun, assaulted, and left with scratch marks on his neck, actually contacted prosecutors and asked the protective order be lifted. Let me repeat that. The victim wants contact with the defendant, even after everything that happened. This is unfortunately a common dynamic in domestic violence cases, where victims may feel pressure, conflicted, or even emotionally attached to their abusers despite the danger. Now, another judge, Judge Susan Brown, made a compromise. She's keeping the no home contact rule in place, but allowing general contact between them. And this judge is mirroring that order, meaning she's following the same conditions. But here's the problem. Protective orders exist to protect victims, even from themselves sometimes. When someone has a history of violence and weapons are involved, allowing any contact can be incredibly risky. The fact that the victim was literally in the car with the defendant when she was arrested for violating the order tells you everything you need to know about how messy the situation is. Do you think judges should allow victims to lift protective orders, or should the court step in and keep them in place regardless? This is a tough one, so let me know your take in the comments.
And I don't know, has a MOA been granted in this case? Do you see if a MOA has been in Ms. Esquivel's case? If a MOA if an order for protection has not been granted, I'm granting one now, ma'am. I'm issuing a protective order that identifies Mr. Longoria as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. You cannot go within 200 feet of the address listed in the order of protection. Do you understand?
Yes, Your Honor.
If you violate this court order, I'm telling you, at that point, you're going to get hit probably with another felony. It's not hard. Now, you've got a great lawyer. Listen to him and he'll take care of you. Because you have a lawyer, I will waive your appearance. But it is your responsibility to stay in touch with him. If he tells me he can't get a hold of you, I'm going to issue a warrant for your arrest. All right?
I understand. Yes, Your Honor.
So we'll have you take a seat. We'll craft all the orders. We'll have you sign it. And then after that, you're free to go.
Okay. Would you
All right.
like me to sit?
You can go out there. Bo, do you want the same date as the felony?
And there you have it. Another intense courtroom showdown that really makes you think about the complexities of the justice system. Let's recap what we just witnessed. We had a 19-year-old defendant with 7 prior charges, multiple aggravated assault cases, and active warrants from another state. She was caught violating protective order by being in a car with the very person she was legally required to avoid, the same person she allegedly assaulted and threatened with a loaded handgun. The judge found probable cause to move forward with the case and laid down strict bond conditions. No alcohol, no drugs, no weapons, and absolutely no contact with the victim. The judge even warned that violating any of these conditions would result in immediate revocation of bond and possibly another felony charge. But here's where it gets complicated. The victim himself asked for protective order to be lifted, and another judge allowed contact between them, which this judge mirrored in her ruling. It's a classic example of how domestic violence cases can be incredibly complicated. with victims sometimes wanting to reconcile despite the danger. The judge made it clear, one mistake, and this defendant is going back to jail with no bond. Now it's up to her to follow the rules and stay out of trouble. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments about whether you think the judge made the right call. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next one.